number 114403, Sage Hill, the State of Kansas, and Ernest Garcia.
May it please the court. My name is Michael Miller. I'm here on behalf of Sage Hill. I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Kansas State Trooper Sage Hill began with the Kansas Highway Patrol in 2008. His entire career, he was stationed in Troop H, which is in southeast Kansas. He owned a home in Troop H in southeast Kansas where he lived with his fiancée. He also had family and friends in the area. Trooper Hill was dismissed by Defendant Garcia from the Highway Patrol in November of 2011. He appealed his discharge to the Kansas Civil Service Board, and there was a hearing. At the hearing, defendants attempted to justify the discharge, but ultimately Trooper Hill prevailed. On December 6, 2012, the Kansas Civil Service Board issued a final order, and this order ordered Trooper Hill reinstated. 1 week later, which is December 13, 2012, Defendant Garcia, on behalf of the Kansas Highway Patrol, sent Trooper Hill a letter. Now, this letter stated that Trooper Hill would be reinstated pursuant to the Kansas Civil Service Board's order, but he was being involuntarily transferred from his home in Troop H to Troop E, which is in far western Kansas. Now, an important fact in this case, which I cannot stress enough, is Trooper Hill is the first trooper that has ever been reinstated by the Kansas Civil Service Board. And he is also the first trooper in at least 40 years that has ever been involuntarily transferred by the Kansas Highway Patrol for any reason whatsoever.
Let me ask you about that. There have been troopers, though, who have been suspended on a temporary basis for discipline, right? I mean, 2 or 3 days. I understand your guy was terminated.
Right.
And then reinstated. But I'm just talking about suspensions for disciplinary purposes. Is there anything in the record about that? About other troopers being suspended, even if it wasn't in dispute, they're being suspended for a few days without pay, and then how they were treated when they came back?
All of the Kansas Highway Patrol command staff agreed that at least in the last 40 years, no one has ever been involuntarily transferred. So as far as an involuntary transfer...
I'm talking about suspension.
It didn't come up in the evidence, so I don't personally know. I assume so, just by the way it works.
And just another quick kind of fact question here. When he was ultimately he requested a transfer to Troop G down the road, which is the Turnpike, and the powers that be determined that on the basis of seniority, he would be the first person to get that transfer because of was the time, what was figured in his seniority? Was the time in which he initially started in 2008, or was it post-termination, or do you know?
I don't know. That's not how we argued the case. The way we looked at it was...
But he did have seniority, and I'm just trying to determine
part of the reason
if his prior service before his suspension counted for in that calculus.
He received his vacation days back, and his so I would assume that it was, but I don't know. It didn't come up in the evidence.
Okay.
Let me ask you one other fact.
Sure.
I know you prepare, but then those plans always go out the window when you show up. When he was transferred out to Garden, or assigned out in Garden City, I'm not worried about the verb here, but when he goes to Garden City, do they pay his expenses?
They paid his moving expenses pursuant to either it's a regulation or a memorandum of understanding, but the damages that he's alleging is after he had to move to Troop E, he still had a house in Troop H.
I understand that. When you're a new trooper,
Yes.
brand new, and you get your first assignment out in the field, do they pay your transportation? Do they pay your moving expenses?
I don't know. It didn't come up in the evidence.
So he got his moving expenses pursuant to the Trooper Association agreement, right?
Or a regulation, yeah, one or the other.
Okay, so we can, and is the agreement in evidence? I kind of think it is, but
I believe it is, too.
Okay. So we can look
And just to be clear, some of the damages he's alleging are not his moving expenses. It's the monetary expenses he suffered having to try and sell his house back in Troop H.
And I don't care about that.
Okay.
I mean, I don't mean to be crass about it. I'm trying to see how he was viewed on reentry.
Right.
And I think that's what Justice Rosen's question is about. You know, so he has service, and then he's reinstated because the termination was decided to be unreasonable. And so this kind of goes to the whether he's treated as a newbie or not when he shows back up on the first day of work after an agency has determined that his termination was unreasonable. You see what I'm getting at? I mean, it seems like he gets back into the pond further downstream than a new guy, a new trooper.
Well, we would argue that it should be, yes, because he's an experienced trooper. And also, what's important is they've never used involuntary transfers ever before for any reason. And the one instance where someone has been reinstated is the one instance where someone has suffered an involuntary transfer. And I'll approach that a little bit later.
Back to the point, you said that he got his vacation pay back,
Correct.
and it was termed a reinstatement. What happened to him? He wasn't rehired. He was reinstated.
Reinstated, yes.
And when he was assigned to Garden City, he was put out in a car by himself.
He was, yes, and that was...
And so, just let me finish. So he wasn't treated like a new hire who would have a period of probation where they have to ride with someone.
correct. At one point...
And so he was treated as the actual facts are that he was treated as a reinstatement back to his old position rather than a newly hired trooper.
Correct. At one point during the evidence, one of the issues was the fact that shortly before Trooper Hill was involuntarily transferred, they placed new recruits throughout the state. And we had questioned, well, why didn't you put everyone that was new in Troop E if there was such a high demand for troopers in E? And defendant's response was, we need people that are trained, that are ready to go out in the field. And that's one of the reasons they claimed that they picked Trooper Hill for the sole involuntary transfer. So to that extent, yes, they didn't treat him like a new hire. They treated him like an experienced trooper.
Counsel, if I could move you to what, in my mind at least, is the very first question, which is, why isn't the state immune from this claim?
The way that the Court of Appeals looked at it was with the Kansas Tort Claims Act and Prager. And the rule with that case and that statute is that if a private person could not be liable, the state of Kansas has not waived immunity. And the first point of my appeal argues that Trooper Hill has assertive cause of action that this court should recognize. Brigham makes clear that there is a tort for retaliatory actions that are less than discharge, and it's necessary to honor those torts to prevent Kansas public policy from being undermined.
But the public policy that you're relying on is a public policy that applies only to public employees, right?
Correct.
It has to, because the public policy at issue is you can't take a retaliatory action against me for taking my CSB rights.
Correct, but that's not the correct test exactly. The Rollins case, which is cited in the brief, states, the test is not whether the same or similar work is actually being done by a private person, but what standard would there be if the work were being done by a private person? So the question would be, if there were a private person that did this, would that person be liable for violating against someone in violation of public policy?
How do we know that the public policy in subsection G adopted by the legislature would be the same public policy to apply to private employers? I mean, that's a big leap, it seems to me. First off, you're asking us to define what the public policy is that the legislature intended in subsection G, and let's assume for the sake of argument that we agree with you on that. I mean, it's yet another leap to say, and the legislature also intended that public policy to apply to private employers. I mean, how do we make that secondary leap?
There are a number of cases cited in the brief where there are actions done by public employers that typically would not ever be done by a private employer. And in each of those instances, the court still did find waiver of sovereign immunity. One of them would be Soto versus Bonner Springs, and that's about a detention officer, and it compared the duties of a detention officer. Another instance would be, well, Rollins in particular involves KDOT, and it's KDOT's duties to maintain the public roadways. And they found that if a private person were maintaining these roadways, it would be held liable for not doing a good job maintaining these roadways. So I think that's one good example where a private person would never maintain Kansas highways.
The question in Rollins was the scope of duty, right? It wasn't the very existence of the claim. Am I right or wrong?
I don't recall that specific in the case off the top of my head, I'm sorry.
Okay, thank you.
Can I, with the time constraint, let me just move you to where what I want to hear. I want to get you all the way to pretext. And at the end of the summary judgment process, past all these other issues, explain to me why the highway patrol's articulated justification for the I don't want to say transfer, but the move out to Southwest Kansas. Again, I don't care about the verb right now, but the assignment out in Southwest Kansas. Explain to me why their justification is not credible.
Sure.
What's your case in front of the jury if you get there on that issue?
First, on that issue, defendants testified, and this is cited in plaintiff's response, that they'd had trouble keeping people in Troop E for decades because it's so remote. Nonetheless, they had never ever involuntarily transferred anybody to Troop E before, ever. And they testified to this, they know that troopers dislike involuntary transfers and it disrupts their families. They also explained that they only transferred Trooper Hill to Troop E. Defendants claim that this need for manpower in Troop E is so great that they had to take this unprecedented action, but the only person that had an unprecedented action happen to them was Trooper Hill, the one person that was reinstated by the Civil Service Board. Additionally, they testified that they only considered Trooper Hill for transfer to E. They didn't look at anyone that might have already been stationed closer to Trooper E that wouldn't have been disrupted. They also didn't look at anywhere else that had excess staff. In fact, both before and after defendants...
Excess what, I'm sorry?
Excess staff.
Okay.
Excess staffing. Following up, the point is both before and after defendants involuntarily transferred Trooper Hill from Troop H to Troop E, they sent out what they call these Make-A-Wish requests, and it solicits troopers for voluntary transfers to go into locations that need troopers. Both before and after Trooper Hill was transferred from H to E, they actually solicited troopers to transfer into H because H needed additional manpower. In fact, at one point after the transfer, there were more counties in Troop H that needed more troopers than there were counties in E that needed more troopers. Additionally, defendants testified, part of the command staff, that they typically don't, well, I guess always, other than in Trooper Hill's case, don't do involuntary transfers because across the entire state, they're short in manpower. And what happens if they shuffle people is it's just, these are their words, it's a robbing Peter to pay Paul kind of scenario. And that's exactly what happened here. They took Trooper Hill from a place that needed troopers and put him in another place that they say needed troopers. Additionally, after the transfer was ordered, the Kansas State Troopers Association contacted Defendant Garcia. They expressed concern that Trooper Hill, being the very first person involuntarily transferred, it appeared retaliatory, and they suggested that maybe Trooper Hill could be placed somewhere closer to his home because there were multiple counties near his home that needed additional troopers. Defendant Garcia refused. And my last point quickly is, after Trooper Hill was transferred into E, which defendants claim had an emergency manpower shortage, at least 2 troopers were permitted to transfer out of Troop E for various reasons. Trooper Hill also tried to get out of E, but they didn't let him. But the point is that if there was such an emergency need, why are they letting troopers come out of E? And finally, I guess my point would be, to rebut defendant's assertion, Trooper Hill doesn't have to disprove the need for troopers in Troop E. There's a true need for troopers everywhere. He needs to make a fact question as to whether defendant's motivation for making the transfer was this manpower need or whether it was retaliation. So whether or not Troop E needs troopers is relevant to the case, but Trooper Hill isn't required to disprove this trooper need.
Not to survive summary judgment.
Not to survive summary
He
judgment.
just has to make an issue of fact.
A fact question, yes.
And my understanding is that Major Eichhorn was asked whether Hill would have been put in Troop E if he had not been terminated and reinstated? And his answer was no.
You're correct. In fact, they considered Trooper Hill uniquely involuntarily transferable because he had been reinstated. And I think that's kind of a key admission on their part.
Thank you.
Any more questions? Thank you, Councilman.
MJ Willoughby, Assistant Attorney General, appearing for the state of Kansas, and Ernest Garcia. In this state, public service, civil service is a privilege. It comes with benefits, and one of these is the protection, job protection against demotion, suspension, or termination, except in accordance with certain procedures and certain grounds specified in the Act, and subject to review by the Civil Service Board and then judicial review in the courts. In response to this protection, and so it's privileged subject to these benefits, but the civil service employee is also subject to the terms and conditions of the Act itself. And these terms and conditions include that there are no damages against your employer except on the Whistleblower Act. The legislature has provided for damages or injunctive relief to an unclassified employee in that situation. So subject to these terms and conditions, the legislature has also decreed that only certain things are reviewable under the Act, and that's the demotions, suspensions, or terminations, unless we're talking about the whistleblower situation, which was added on the separate statute. So in this area, and those sentiments about the privilege, the benefits, the terms and conditions were from Gray versus Jenkins in 1958. And the court was correct in that regard, and the legislature has occupied the field of public employment in this state. There is no room for a common law here. There is no other area where the legislative intent to control is stronger. And that's because the paramount public policy here, expressed in 752925, is for an effective and responsible state workforce. Because if you can't control the government, if you can't control government employees, then you cannot provide efficient and effective services to the taxpayers and the citizens. And this is particular.
And so retaliation is an effective means to effect an effective and responsible workforce.
Well, if you're talking about this assignment, the superintendent.
I'm talking in general. You were talking in general, the global discussion.
True.
And I'm talking globally. Then we have to allow retaliation for exercising the rights that you concede they have under the Civil Service Act with retaliatory steps, and that's globally that's necessary to affect the goals that you outlined.
I would say yes, in the sense that the Civil Service Act itself is a complete scheme. There's no room for common law. There's no room for implying other things. The Act provides 752952, 752957, 752958. They all say no officer or employee shall violate the Act. There are criminal penalties. It's enforceable in that way. And there is also the Whistleblower Act. So if the claim is it was retaliation for that activity, the legislature has expressly provided for that ability. The other thing on your point on retaliation is if it's a demotion, suspension, or termination, it is subject to review under the Act. It would just be minor, what we would call minor personnel actions. But the other point I probably need to make is that the Highway Patrol is quite unique. It has statutes that recognize, there's three of them, 742106, 742107, 742114B, the superintendent's ability to assign troopers anywhere in the state of Kansas. And everyone who joins the patrol, including Sage Hill, signs a document agreeing that being subject to assignment is a condition of their employment. And it's a paramilitary organization. They go through the chain of command. And that's both because you need to be able to provide coverage across the state And we did try to provide as an appendix a color map on the staffing situation. And in color, it's all red out here in Garden City, Finney County, in that area. And so it was the most critical need of the entire state. And that's 25,000 miles of Kansas highway left effectively unpatrolled. And so the superintendent has the ability from the legislature to deal with that situation and try to assign resources, which are scarce everywhere and at all times, to the area of greatest need. So in terms of some of the questions that were asked, they did view him as a new body that was available for assignment because he was coming in as a new employee.
Can they do that for any reason they want?
Yes, under the statutes, the superintendent's subject to.
I don't like you, so I'm transferring you. Because I don't want to see you around here anymore.
Correct. Subject to the payment of moving expenses, which he was paid.
That's your argument, is the statute does not prohibit the superintendent to effectuate a transfer for any reason.
That's true.
So the
statutes.
pretext that council was arguing doesn't matter. Doesn't matter.
Well, it doesn't under the statutes because the superintendent has the right and discretion to make management decisions.
So superintendent can transfer you anywhere for exercising First Amendment rights.
Well, let me back off a little bit here. We're not necessarily saying that all federal statutes and federal rights necessarily go out the window. But in that case, I think Connolly would say if it's a classified employee subject to the act, even if you're making a 1983 claim, for example. And I think Prager would say the same thing. And the problem with this argument, this retaliation argument, is it's so easy to say. And these days, and so that's all.
Both ways, Counselor.
Right.
It's easy to say both ways.
Exactly. So in the rule that he is asking you for, and I think this is
But the problem with your side of saying it is that you can talk the talk, but you need to walk the walk. And this gentleman was not treated like a new hire. He was sent to Garden City and put in a car by himself. And new hires have to have a period of ride along. He was given his vacation pay back. So he wasn't a new hire. He was allowed to apparently keep his seniority, at least in some respects. And so when you say he was a new hire, he was, that's only for purposes of transfer, not for other purposes of supervision.
That's true. He didn't have an existing duty station. He wasn't a state employee for a year. He had no gun, no badge, no car. He was working for the county.
And the
under
only
county
reason
commission.
he was in that void is because of an unreasonable action by the employer.
Well, it wasn't that unreasonable because the Civil Service Board overturned the termination but put in place a suspension, a 1-year suspension, which is quite, and it also said that Mr. Hill would benefit the employee under different supervision.
I only go, I mean, there's any number of adverse job actions that occur under a given circumstance. The termination, which is where you're trying to hang your hat, was found to be unreasonable. And on the moving expenses, I heard you say sort of that they did pay his moving expenses. Do they pay the moving expenses of the new troopers?
I don't believe so, but I can double check and do a supplemental on that. But the reason is
and if they don't, then aren't you right back in the same boat that this is a reinstated trooper, and so the fact that he's the only guy that had an involuntary transfer and it's so close in time to being reinstated, it does look like you could have a jury question there as to what was motivating the superintendent and the command for sending this trooper out to Southwest Kansas when he was already living in the other part of it.
Well, the only evidence that Mr. Hill ever brought was basically what you're saying, and that Mr. Garcia looked upset with him at the end of the Civil Service Board hearing. But all of our evidence were there were 4 majors and a lieutenant colonel that recommended this assignment to
Well,
the colonel.
that's an evidentiary dispute. Let me
Yeah.
try to ask what I think is Justice Bowles' question, but take it from a different angle. What, in your view, does 2949G prevent the state from doing or prohibit the state from doing? And that's the statute that says no employee shall be disciplined or discriminated against in any way because
Well-
they use the CSB appeal procedure.
Right. Discipline has definitions within the Act: demotion, suspension,
G
termination.
is broader than just discipline. It talks about discriminated against in any way.
And discrimination is also defined in the Act as political or religious. And so that question, the biggest, so that is a prohibitive action, but the statute itself deals with if an officer or employee violates the Act, then they're subject to criminal penalties. Now, the problem with the...
But, well, let me...
Yes.
This individual exercised his rights under the appeal procedure, and now he's saying something bad happened to me as a result of that. And I'm just asking you, what in your view is the state... I mean, G obviously is there to tell the state you can't do certain things because somebody exercises their appeal rights. And I'm just trying to figure out what are those certain things that the state can't do.
Well, that's a very good question. The way that the problem with Mr. Hill's argument, and this is what the Court of Appeals struggled with, is that in any way language is so broad as to basically be hortatory.
It's
In a
in the
sense.
statute.
True. But the in any way, it doesn't mean, I think Mr. Hill's interpretation is that anytime management makes a decision that a trooper...
Well, let me put his argument in what
Yeah.
appears to me to just be layman's terms. It is that the statute means you can't treat me differently from other troopers just because I appealed. And if that, isn't that a reasonable interpretation of G? You can't treat me differently because I appealed.
True. And so in terms of the different treatment though, if you have an act that as a complete measure provides for review of demotion, suspensions, terminations, and also the whistleblower section, which also provides for transfers under that one. And you have a 1978 revision, which we provided, that thick stack of papers, which shows this was a comprehensive system. So it wasn't that the legislature, didn't think about these things.
So you think that the state, the Highway Patrol, is allowed to treat troopers differently on the basis of whether they exercise their appellate rights under the Civil Service Review Board process?
No, that's prohibited. But the question would be, what is the remedy? But here there was no evidence that that was the reason. All the evidence was there was a dire situation out in Troop B. And then there was also the Civil Service Board saying, we think he would do better under...
Well, arguing that we win because there's no controverted evidence to support their claim is different from arguing that we win because there's no claim.
Well, there's no claim also. I guess the fundamental proposition back to the immunity question is the state in the Act provided for review of certain things, but it didn't provide for review of every management decision. And as he joined the patrol, agreeing to being assigned everywhere, as on the discretion of the superintendent, subject to payment of moving expenses. And so that is a situation where, say, under the federal civil service, they've said, well, the fact that there isn't a damage remedy doesn't mean that the whole statute is no good. That's part and parcel of the entire arrangement, which is what the court was saying in Gray versus Jenkins, what the court said in Wright versus Kansas Water Office. This is a statutory relationship, and if it's not in there, there's no room to create.
Your argument is that while G may prohibit the Highway Patrol from treating troopers differently for this reason, that it doesn't provide a remedy. Like it may say you can't do this, but it doesn't provide any review remedy.
Right, except when there's a whistleblower situation.
Only the remedies provided in other statutes, not a common law remedy.
Correct. There is no common law. There's no room for the common law because that could be disruptive of the scheme. And in the superintendent situation, which is kind of unique, the whole paramilitary issue. They may have to send a trooper out to do a natural disaster or work civil unrest, and if, you know, maybe they can't get a volunteer, but they have to be able to make orders to assign people without being subject to being lawsuits. And here we've been in this case since 2011, one way or another. And your issue about whether he was treated as a new employee or not, you know, I think the state was trying to do the right thing at the Highway Patrol in terms of responding to the board's order, and that's why they didn't, may I finish? I'm at 0. They didn't want to in any way penalize him. So they included his seniority, his sick leave, his vacation leave, but on the other side of that, there were many other statutes that had to be complied with technically to be a new hire, which is taking the oath, resigning your county commission, because you can't serve as both. He needed a duty station, he needed an assignment. So in some ways he was new, but in some ways not, because it was such an unusual situation. Never happened before and hasn't happened since. So for the reasons we've stated in the brief, we would ask the court to affirm the Court of Appeals dismissal of this action. Are there any other questions?
I see no questions. Thank you, counsel.
I have a few responses to some of the points raised. Goolsby, which is cited in the briefs, makes clear that the fact that a legislator has not enacted a statutory action is not any evidence of all for any type of non-existence of any type of public policy honoring the act. Additionally, as I think the court realized, if employers are permitted to retaliate against employees for utilizing the Civil Service Board, we might as well not even have it. There's no point in giving these employers rights when they're coerced from ever using them. Second, some of the language counsel used about looking for implied causative actions, that was briefed throughout. Trooper Hill is not asserting any kind of statutory cause of action. He's asserting tort. So looking at legislative intent is not appropriate. We're supposed to look at the common policy and whether or not recognizing Trooper Hill's tort would undermine the entire Civil Service Act. Trooper Hill submits it would. We also looked at some of these agreements Trooper Hill signed when he started with the Kansas Highway Patrol. The fact that he agreed that he could be placed anywhere doesn't mean that he's waiving any kind of rights. Like some of the judges noted, it doesn't mean that he has no First Amendment rights. It doesn't mean that he's agreeing to be treated or discriminated differently because he appealed to the Civil Service Board. We've seen this map. The map was attached to many of the pleadings and motions. The defendants testified that during the meeting where they discussed Trooper Hill's transfer, they didn't use this map. In fact, defendants explained that the reasons and the manner in which they allocate troopers are based on many factors, and they try and do what they think is best for the troop. There was also a discussion about some language in the Civil Service Board's order about Trooper Hill possibly benefiting from other supervision. Defendants never, ever, ever mentioned that as any of the reason for the involuntary transfer. They've hung their hat solely on the fact that it's because of this emergency manpower need. This new explanation has come up in the briefs and on appeal and in the motions, but never from an actual witness's mouth. I'm going to go back a little bit. So one of the things that the Court of Appeals looked at, which I think is interesting, is they kind of focused on harm. And they said that an involuntary transfer is, as a matter of law, not harmful because it's not tied to a person's wages or benefits. And I think they made a mistake, honestly, because I think what they were looking at is Title VII law through federal cases. And the Title VII statute has two types of prohibited acts. One is discrimination, we'll call it substantive discrimination, and also retaliation. The Burlington Northern case explains that substantive discrimination has to be tied to wages and employee benefits by definition of the statute, whereas retaliation under Title VII can be much more broad because as lawyers, we can think of lots of ways to retaliate against someone that's not related to their wages. And some of the cases the Court of Appeals cited were actually looking at some of this Title VII law where the actual text of the statute required the claim to be tied to conditions of employment, meaning wages, benefits. And obviously Title VII is different because it's a statutory cause of action, but I think some of the language the Supreme Court uses and what they look at to get to their conclusion could be useful for the court. In fact, the standard they used was whether the challenged act might have dissuaded a reasonable worker from engaging in the protected conduct. And here Trooper Hill would submit that A, he did suffer retaliation in any manner, and B, if the court wanted to look for some type of standard to possibly apply, the one in Burlington Northern could be a useful one. We believe that an involuntary transfer across the state is sufficient to dissuade a public employee from appeal. For these reasons, Trooper Hill requests this court reverse the Court of Appeals' reversal of the District Court's denial of the motion for summary judgment and reverse the Court of Appeals' affirmation of the District Court's grant of summary judgment, and also remand this case back to the District Court. Any questions?
Any more questions? Thank you,
Thank you for
counsel.
your time.
We appreciate the arguments of counsel this morning. Court will take this matter under advisement.